this webinar with regards to what defenses do you have to break your lease. I just want to just sort of at the outset just sort of say what I normally say when I begin these webinars, and that's to applaud the efforts of Palante as far as organizing and empowering New York City tenants to join together and collectively enforce your rights. Uh, the only way that tenants are able to have any power is if they organize and team up with organizations such as Palante. So on a personal level, it's a wonderful professional, um, brings me great professional and personal satisfaction to partner and work closely with Palante as I do, and be able to participate and in these webinars on Thursdays. So without further ado, I want to sort of spend a few minutes, and then I do think the best way to do these is to engage in somewhat of a discourse surrounding the topic. But I do want to kind of give a little bit of a talk, if you will, with regards to how do you break your lease, right? And um, interestingly enough, this is a topic, and we were talking about this before we got started, that's a little different than a lot of the topics that we discuss as far as Zoom Thursdays. A lot of the topics are geared towards understanding your right to remain in your apartment, right? Or understanding your right to succeed to a rent stabilized apartment or to collect an overcharge for your apartment or etc., right? This is a complete 180 from that, right? This is a situation, and it does arise, where a tenant, for whatever reason, wants to break their lease, right? You have a lease, um, it has a term, right? That's what a lease is. It has a start date and it has an end date. And if you sign a lease, whether that's for a year or whether that's for 2 years, sometimes things will happen and you will want to get out of your apartment before your lease ends, right? That's what we're talking about. And I want to make sure I'm clear about that. So let me start with rent stabilized tenants. Uh, I think if you were to tell your landlord and you're a rent stabilized tenant that you are leaving, their reaction very well might be great. And that might be the end of your exposure as far as potential problems. For market rate tenants or other that might there might be a different story. So back to what I initially said about a lease having a term, right? That's important to understand because a lot of folks are under the impression that if they sign a lease, let's say in January of 2026 for this year, and it goes through December 31st of 2027, and let's say we're in May, right, of 2026, 5 months into that, that lease that I just made up. And I think a lot of people think, well, if I want to leave, I just tell my landlord I'm leaving and I'm good, right? I just pack up my stuff and go. And how could I possibly owe rent for June if I'm not living there, right? How would I possibly owe money for an apartment if I'm no longer there? That is totally wrong. You absolutely owe rent for the apartment, even if you leave, right? And we're going to talk about that. And that's sort of where the crux of my talk tonight lies, right? How do we do what we need to do to ensure that the landlord doesn't come at us, right? Or come back and try to sue us for months and months and months and months remaining on your lease. And, again, I don't never, ever do the landlord's bidding for them or make arguments, but a lease is a document, right, that does have a term, right? And I always tell tenants this when they seem shocked. They're like, wait a second, if I give the keys back to the landlord and take all my stuff out and broom clean, you're telling me I could still owe rent for the next month, even though I left? And I'll say, absolutely, because there's time on your lease. And what I do at that point is I tell people, Well, what would happen if the landlord knocked on your door and said, "Hi, I know you have 6 or 7 or 10 or 12 or 15 months left on your lease, but I don't think this is working. I don't want this anymore. You have to leave." We would laugh at them, right? We would say, "You got to be kidding. We have a lease. You can't just cancel it and take back what we lease, which is the apartment," right? That would never happen. So similarly, right, if a tenant decides this isn't working, it's too expensive, I got a better deal, I can it doesn't automatically terminate a lease because you move out, right? So that's the first thing to consider. The first thing I want to talk about as far as defenses to have to break your lease, the first thing that's incredibly important is that you surrender the apartment, right? That's the first thing that you need to think about how to do. You can't just leave and assume the landlord knows that you left, right? You have to affirmatively inform the landlord that you're leaving, and you have to return all keys to the apartment and the mailbox and the building, all keys, right? And I always tell folks you should do that in a way you can track, right? So you would want to send that by, for example, certified mail, or you would want to bring it to the management office and get them to sign a receipt if there is a management office. You don't want to leave it to chance that you may have to prove that you left your apartment and not be able to prove that you affirmatively informed the landlord, right? So that's important. And why is that important? Because now, with the passage of the HSTPA in 2019, um, the landlord is under a duty, an obligation to what's called mitigate their damages. So the landlord must take affirmative steps, and the way the statute reads, it's commercially reasonable efforts to re-rent the apartment. Before the HSTPA, there was no duty for landlords to mitigate. So if a tenant left early, the landlord could leave that apartment empty and go after the tenant for all the rent remaining on the lease. But that is no longer the law, right? The law now says that a landlord must make commercially reasonable efforts to re-rent the apartment. And why is that important? That's important because we live in New York City and it's not hard to rent an apartment. There's a huge demand for apartments. So if you move out and your landlord puts your apartment commercially reasonable efforts, that would be like listing it for sure. And they list your apartment. If it takes the landlord a month to get someone in there, you might be on the hook for that 1 month. If it takes 2 months, it'd be 2 months. But almost always, right, the landlord, if they're complying with the law and using those commercially reasonable efforts to re-rent your apartment, they're gonna find someone and they're gonna find someone fairly quickly. And once they do, and once they put someone in that apartment, your exposure, right, your liability ends, right? So that's why it's so important to trigger for the landlord that duty to mitigate. And that's triggered when you unequivocally surrender your rights to the apartment in the way that I just said. So that is the most important sort of thing to know. I think when you're talking about leaving apartment early, when you have a lease, is is surrendering the apartment clearly, right? As I talked about, giving back all the keys, doing that in a way that can be tracked, right, and proven, and then triggering that duty to mitigate. That's critical. All right, but what are some of the other defenses, right? So that's sort of if there's no defense, really, right? And a defense would be, and then you would pay attention, right? You would look and see if the apartment was listed. And if a landlord doesn't do anything, right? If a landlord just sits with the apartment and does nothing, then they can't go after the tenant for rent, right? Then they didn't comply with the law. They didn't make any efforts to mitigate their damages, and they will lose. No court is gonna rule that a tenant owes rent on a lease if the landlord didn't try to re-rent the apartment when the tenant left. Okay, what are some of the other defenses, right? So some of the other defenses. So a lot of times people move out of an apartment because it's just they can't live in it because it's just unlivable, right? That the conditions in an apartment don't allow them to stay there. That's called a constructive eviction, right? And a constructive eviction means that and here's the key part of this phrase, right, is the objective, not the subjective, but the objective conditions in the apartment don't allow the tenant to live there. And if those conditions then exist, right, that is an absolute bar to rent. And you have to leave in order to trigger the constructive eviction doctrine. Meaning what? Meaning it's not enough to tell the landlord, there are terrible conditions in my apartment, and therefore I'm constructively evicted. You're not constructively evicted if you're still living there. Evicted means evicted. Constructive means the landlord didn't say to you, tenant, get out. I'm not letting you. That's an eviction, an actual eviction. Here it's constructive eviction, right? Because the landlord allowed conditions to fester or didn't repair things that ultimately resulted in the tenant leaving. So if you have egregious conditions in your apartment and you leave because of those egregious conditions, it very well could be that you have a defense, which would be constructive eviction. Now, the clearest example of a constructive eviction, and it's not exactly on point, is when, for example, let's say there's a fire, right? Or a structural stability issue in the building, and the Department of Buildings or HPD issues a vacate order, right? At that point, you can't live there because the city of New York is not allowing you to live there. So you've been constructively evicted from your apartment. The landlord didn't do it. The city of New York did it. Um, Now, all the time, this comes up and people will ask me and say, I have these conditions. I've been constructively evicted. And I think it's important for me to sort of illustrate to folks what is a constructive eviction as far as what conditions would lead a court to conclude that the apartment was so unsafe that nobody could live there. Well, there are some clear examples, and I'll give them to you now. For example, if you have no running water in your apartment, no running water, no court finds that it's anything other than appropriate for a tenant to leave, right? Nobody can be expected to live in an apartment in which there's no running water, that you would have to go to a neighbor's house to go to the bathroom or to bathe. That would be 100% every court constructive eviction. If there's no bathroom, constructive eviction, right? Like the ceilings fell in, you can't use the bathtub or the shower, you can't really use the toilet because there's debris everywhere and the landlord won't fix it. That's a constructive eviction. Um, it's also helpful to understand what's not a constructive eviction, and it actually sometimes shocks me when what courts find to be not a constructive eviction. So mold is definitely not a constructive eviction, right? No court has found that that's not a constructive eviction. Rats, not mice, rats running around, not a constructive eviction. Not sufficient. Doesn't get there, right? Um, and it is again, it's a little legalese to be talking this way, but it is the objective conditions, right? So if someone is legitimately has a phobia, right? Even diagnosed of like, let's say rodents or bugs, and there's bugs everywhere and rodents everywhere, and I can't live there, right? It's just too, that's not a constructive eviction, right? So it's the objective conditions, and they have to be downright horrible for it to rise to the level of a constructive eviction. Okay, so that would be an absolute defense, right? An absolute defense to any rent at all if you're constructively evicted. But you do have an alternate defense, and that would be that there's warranty impairing conditions in your apartment, right? So a lot of times people leave because of conditions, right? And they're like, I'm not paying this rent and living here when I can got an opportunity to go get it. So if it doesn't rise to the level of a constructive eviction, it very well would be an abatement of rent, and the abatement of rent would go back for however long it was that you were living in the apartment. You go back 6 years on a warranty claim, on an abatement claim. So that's another potential defense, a defense to breaking your lease, right? That there's objective conditions in the apartment that that don't that don't rise to the level of a constructive eviction, but certainly warrant an abatement of rent, right? So oftentimes, and I'll talk about the last defense in a second, oftentimes I find the best way to deal with a situation in which there's conditions in an apartment, but it doesn't rise to the level of a constructive eviction, is to try to negotiate a surrender with the landlord before you leave. Because sometimes what the landlord would want is they want the apartment back. They think they can rent it for more, or you're on to them, so to speak, as far as their, nonsense, and you're not going to stand to be living in substandard conditions, and you're going to withhold rent, and they just rather get in a different tenant who would be more willing to go along with whatever it is that they're pushing. At that point, I think it's advantageous to try to negotiate some sort of settlement with the landlord whereby they waive a month of rent or you pay a month of rent and you sign mutual releases and you get out of the lease and you insulate yourself from being on the hook for all the months left on the lease. The same holds true as far as asserting potentially that you're a rent stabilized tenant, right? Or you've been overcharged. Again, they have to be viable. It's not going to be enough just to say it. But one of the things I always tell people in this situation is go get your DHCR rent registration history. We've talked about that a lot on these webinars, right? And you might find something, anything that the landlord feels a tiny bit of risk about. Maybe this apartment could be rent stabilized. If you do that and you go to the landlord and say, I want to get out of my lease, they might very well just agree. Instead of having a situation on their hands in which a tenant is asserting rent stabilization rights, right? So that's another possible way to get out of your lease if that's indeed what you want to do. And then, of course, one of my favorite defenses is the certificate of occupancy, right? This would hold true for like if you're sued for a non-payment of rent, but certainly there has to be some due diligence. And if the building is occupied in a manner that's inconsistent with the last C of O, certificate of occupancy, or the building doesn't have a certificate of occupancy and has been altered, then that would be a bar for every tenant in the building from having to pay rent. And that's certainly something that you would want to look at as far as any lease break, because if you have that as a defense, you don't have to worry about being on the hook for rent once you leave. All right, so with that, and I promised myself I would try to keep this relatively short. That's my sort of outline, right, of your defenses if indeed you are confronted with a situation in which you have a lease, you don't want to live in the apartment anymore, you want to move out, right? What I just laid out are some of the ways that you can do that and potentially insulate yourself from being on the hook for the rent on the remainder of the lease. So with that, I want to open it up and discuss or take questions and etc.
Okay, thank you, Jesse, so much. We do have quite a few questions that came in, so we're going to start with the first one, which is, does a landlord's failure to maintain the apartment ever justify lease termination?
One more time, Jakari.
Does a landlord's failure to maintain the apartment ever justify lease termination?
Sure, it does, as I just laid out, right? It's not going to be enough to say my stove doesn't work, right? It's not going to be enough to say I don't have gas service. Those things for sure are reduction of the rent, but it's not a complete defense to getting out of the lease, right? It's not the law that says if I have this condition or that condition, I'm justified in leaving. That's not what the law is. It allows you to leave if you've been what's called constructively evicted. And I just talked about what that is. It's a very, 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 very high standard, right? So again, if you have no running water or you have no electricity or you have literally ceilings falling down everywhere and like anybody that walked into that apartment was like nobody could live here, nobody, that would allow you to get out of the lease. But if you have like a leaks or you have mold or you have mice or right, those are not going to be the type of conditions that a court would say, absolutely, you can go, you don't owe anything, you're done. Those are two very, very different things. I want to make sure I'm being very, very clear about that.
Okay, got it. The next question is, if a tenant is being harassed or feels unsafe due to other tenants or the landlord, what legal steps must be taken before breaking the lease?
Oh, that's a good one. So the thank you. That's a good. So that would also be in the realm of a constructive eviction and or severe tenant harassment, right? So if you have a neighbor, right, who's violent, right, and has assaulted you in the hallways, and you've gone to the landlord and you've told the landlord, and the landlord doesn't do anything, that can rise to the level of a constructive eviction, right? You're not safe, right? If someone's attacked in their hallway, by a neighbor, I don't think a court would say that it was unreasonable for them to leave. I think the court would say it was reasonable for them to leave, and that would hold up. But again, there's like nuance here, right? If it's a neighbor just a pain in the whatever, playing music, your normal, I hate to say, normal New York City disrespectful, terrible neighbor, that's not going to be enough, right? It would have to be like 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 I said, some sort of act of violence or some kind of vandalism, right? Or criminal criminal activity, I think is maybe the best way to think about that. Not horrible activity, but criminal activity. If that's afoot, then I think yes, it could be a situation where a court would say you were justified in leaving and therefore you owe no more rent.
hmm
I
Um,
also want to make sure I'm clear too about something too, right? Like a lot of times in these situations, people haven't paid rent in a few months, right? They're like trying to, get the landlord to do something. And what I'm talking about when you leave, do you owe rent for the months after you leave, right? Whether you owe rent for the months that you're actually living there is a totally different discussion, right? I'm talking about only when you want to get out of your lease or leave the apartment, right? That's what I'm talking about.
mhm. Are tenants allowed to break lease due to job loss or relocation, even if hardships are proven?
No, that's a good question too. No, the answer is no. I wish there was. We're all like tenant folks here, and I wish there was a law that said, upon a showing of just cause or changed circumstances or necessity, a tenant is allowed to break the lease. None of that exists. None of that exists. None.
Mhm. The next question is from Alfredo. Is water damage a reason to break your lease?
No, no. Well, it depends, right? If it's water damage, well, first of all, too, let me be clear. You can't have a leak and then say I'm leaving, right? Like you have to give the landlord an opportunity to fix something, right? So if you're saying is there water damage, like there's degrees of water damage. If it's a leak and the ceiling caves in and there's debris, the landlord won't fix it, and there's a gaping hole in your ceiling, and every other day more of it's falling down. Well, that's one, and they won't come, they won't do, that's one set of facts. If it's like a leak that's been there over the years and like they fix it, it comes back, it drips, there's a little bubbles on the ceiling, it drips, that's never going to be considered. Every judge will say that happens in, half of the apartments in New York, and they're never going to say that that's something that would rise to the level of allowing you to get out of your lease, right? So um, hopefully that's clear.
Mhm. What rights do market rate tenants have?
Well, I mean, a broad question. As far as just broadly, what rights do market rate tenants have? What I'm talking about as far as today with breaking your lease, it's the same applies to stabilized tenants and market rate tenants. I do think that stabilized tenants are situated better to because the landlord wants their apartments back, right? The landlord wants you to leave, right? As in market rate tenants, the landlord doesn't really want you to leave, right? You're paying market rent. You're paying what the market can bear. But all of what I've talked about so far is true for market rate tenants, as well as stabilized tenants. Market rate tenants have rights now that they never had before. We have good cause eviction, right? So unless your landlord is exempt, and this is not a webinar about good cause eviction, we've done those and we'll do those again. But if you're certainly covered by good cause eviction, if you're covered by good cause eviction, and most market rate tenants in the city now are, you have significant rights. You have the right to stay in your apartment. You have a right to rent increases that are, they're not rent stabilized increases, but they're not market rate increases either. You have notice, requirements. If you've been there for more than 90 days, I'm sorry, more than 2 years, you get 90 days notice if they're not going to renew your lease. You have the right not to have the landlord retaliate against you. You have the right to an abatement if there's conditions, and you have plenty of rights as a market rate tenant. You're not under the same statutory scheme as stabilized tenants, but there's lots and lots of rights that market rate tenants have.
And we actually do have a webinar next week on good cause eviction. So
Oh, perfect. There you go. Great segue. Good plug. Everybody should attend that. Good cause is really important.
it is. The next question is from Mona. What about if Con Edison turned off the electricity to the apartment if the tenant didn't pay the money owed to Con Edison?
Yeah, you can't do something that you did and then use it that's a good question too. I don't know if it was meant that way, but it's a great question to have me clarify, right? Like I think it goes without saying, but you can't go into your apartment with a sledgehammer and take it down, right? Take down everything, the walls, the appliance, and then go to the landlord and say, "Hey, yeah, I can't live here." And anybody that looked at the apartment would be like, "Yep, nobody could live here." But you can't live here because you did it, right? Like, so that's not going to work. Same thing. If you're responsible for electricity and you don't pay electricity and they cut the electricity, you can say, "Hey, well, nothing I can do. This is not livable. I can't live here," right? Like that's not going to be. It has to be something the landlord was responsible for. The landlord did, right? This is a defense to an act by a landlord. You couldn't use something that you did in order to, or didn't do in order to avail yourself of that defense.
Okay. We have a question in Spanish.
Sure.
So I'll wait for. Okay.
I do. Not based on, no, not based on you having a lease in effect. There, I can't answer if there's some other basis. Like if you don't pay rent, there might be a basis. If you engage in like objectionable conduct, there might be a basis, but there's no basis to say you don't have a lease if you have a lease. There's no basis to say you have no right to be here, therefore I want you gone. That would be wrong because you do have a right to be there. You have a lease, right? So,
Okay. What is the risk if a tenant just moves out without legal justification?
that you would owe all of the money on the lease. So if you leave and you have 10 months left on your lease at $2,000 a month, there's a chance you owe the landlord $20,000 for the rent after you leave. That's your exposure.
Okay. Next question comes from Sadie. Does environmental hazards, i.e., arsenic, mold, lead, asbestos, in home supersedes a fire from next door neighbor.
Yes, that sounds like a constructive eviction that would allow you to get out of your lease, right? If there's documented asbestos and other environmental safety concerns, remember, ultimately it's an issue of fact, right? It's like, right, there's not going to be exactly the same set of circumstances for any case, right? So just think about it. If it's a judge that's listening, and to me, you hear there was a fire, there's documented asbestos exposure, or friable is what they use for exposed, like exposed asbestos. There's toxic mold. There's like, I don't think a judge would say, nah, you got to stay there. You got to live there. There was no basis for you to leave. I think a judge would say, yeah, you were justified in leaving. The reason why I brought up the other examples is because I think if you're, I'll give you another real example from a case, a real example. A young couple, right, had their first child, and the child woke up in the middle of the night, newbornish, within a year of age, and they went to the crib and they picked the baby up, and the baby is literally like swarming with bed bugs, like everywhere. And they're like, not only they like left, they left the apartment. They're like, my baby's getting bit, and this is like it was traumatic. And the judge said, no, 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 no basis, none. Bed bugs they're all over the city. Everybody has them, or every three apartments have them. That's not a basis. You get an exterminator. You got to let the landlord do their thing. It is not the judge. Essentially, what the judge was saying is, I'm not writing a decision, right, that's going to then allow anybody in New York City with bed bugs to leave their apartment and not have any liability for the rest of the rent. So the judge didn't do that, right? So the reason why I say that, I just want to make sure that people are thinking in order to get out of a lease, the condition has to be horrific, right? It has to be like nobody could imagine that anybody would say it's okay to live there. And the points I'm making about the bed bugs, the rats, not the mice, right? And it's that judges are very, very reluctant to do that, right? Because we have terrible conditions in apartments and right. So that's the reason.
Mhm. The next question comes from Renee. Is there any advice on how to negotiate with the landlord to get out of a lease early?
Yes, yes, there is advice about that. That's a great question, right? So what you want to do in those situations, right, is you want to do your due diligence, right? You want to do your homework. That's what due diligence is about your apartment. Is there a C of O violation, like I mentioned? Is there some basis to say that you're being overcharged, right? So that when you go to the landlord, you're not just begging them to allow you to leave your lease, right? I'm going to talk about that in a second, but the better approach is to go to the landlord and say, hey, landlord, I don't think I owe you any money, and here's why. Or I think you owe me money because I paid you rent until this time, but I've lived with mice and I've lived with leaks and and I'm going to sue you, right, for a proper abatement, right? If I'm paying $2,000 a month, and I got all these conditions, I might be entitled to $500 back. And I've lived here for 7 months, so that's $3,500. And the landlord may or may not at that point just say, you know what? Yo, let's just have a divorce. Like, yo, like don't sue me. I'm not gonna sue you. Time to go, right? Like let's end this relationship. That's what I try to do for my clients. I want to get out of leases, right? We try to go to landlord. You try to get to an agreement and you try to leverage any defenses you have towards that. Now, sometimes there are no defenses, right? Sometimes the landlord doesn't care about your defenses. And then the question becomes is, do you try to limit your liability by offering the landlord something, right? Like, so for example, let's say I have a lease that doesn't end for another year, but I got to get out of there this month and I don't have any defenses. Sometimes I'll tell people, or I try to go to landlords and negotiate for my clients and say, you know what? I'm letting you know now that I'm leaving so you can start showing the apartment now, right? I'll let access, I'll let you in. I want to help you get this re-rented. That's the first thing. Second thing, you can keep my deposit, right? Meaning I'll pay you up until the time I leave and you keep my deposit. And therefore, if you find someone right away, you're going to come out a month ahead because you get to keep my deposit. And then if they say no, I'll pay you a month of rent, right? I'll pay you for a month that I'm not living there and you keep my deposit, right? And at that point, a lot of landlords say okay, right? Because they get like 2 months of rent. It's like a bird in the hand. And then they figure they're going to rent it out earlier and then they're going to make money. So then you say, well, why would you do that? And the reason why we would do that is because some people really want like peace of mind, right? They don't want to leave an apartment and think, man, the landlord might find me, then he might sue me, and I might owe this amount of money. They would just rather sort of, even if it means paying a little more at that moment, be done and like have it just totally, X'd out. Like I'm done with that apartment and nobody's going to come after me and nobody's going to. So those are the two ways to kind of go at your landlord to try to negotiate some sort of lease break, right? Is to sort of go to them first and foremost strong, right? And say, you want to do a divorce with me because if you don't, we're going to end up in a battle and here's what I'm going to do. And they might, okay. And the second one is to say, listen, I'm leaving. Can I give you something to let me out of the lease? Is there something that I can offer you to let me out of the lease? Those are the two approaches.
The next question we have is from Carolyn, who says, if the landlord has a duty to mitigate after the tenant leaves and the landlord must properly list it, what if the landlord first wants to rehab the apartment and repaint it, etc.? How long can the landlord drag that out for? And does that still count as the landlord taking mitigating action so the tenant won't have to pay for any additional months of rent?
Good question. These are really good questions today. So that's a great question. So that comes up a lot actually, and Um, I think it's very, very fact specific and dependent, right? So if you leave an apartment, and that's why, again, and let me make sure I say this. Remember I said about surrendering an apartment and how important it is to send the keys, and you also have to take photographs and videos of the apartment when you leave, right? Because the landlord could claim that there's damage when there's not. I tell people, go crazy. Everybody got a phone, start videotaping, do like, and not just like broad pictures like up walls and ceilings and like it takes a few minutes, but it's worth it to have. Okay. So if you have a video and photos that shows your apartment is in like really nice shape, but the landlord decides they want to like, really like, do some like fancy renovation and put in, that the court's not going to allow them to get to like, and they want to spend months doing that, right? Like in, with a contractor and a whole to do. The court's going to say that you didn't mitigate your damages. You made a decision to renovate this apartment, right? You didn't try to rent it. You tried to renovate it because you thought it was going to make you more money down the line by renovating it. And then you can't then use that time that you were renovating it to charge the tenant. That doesn't make any sense. Okay. But if it's a situation in which the apartment is a disaster and nobody would rent it at the condition it is, and that is sometimes what happens. I want to be fair about that, right? People, and nobody's fault. I mean, somebody lives in an apartment for 5 or 6 years, they got a couple kids, they leave that apartment, it's not exactly in like perfect rentable shape. So maybe what the landlord says is, I got to beautify the apartment a little bit. Like what? Like stain the floors, right? Like do a paint job and it might take a 2 weeks or something. That is going to be something that's not going to be like they didn't mitigate their damages. And in fact, the court could say about that is you should be happy they did that because if they didn't, nobody would have rented it. Then you'd be on the hook for the rent, right? So, we list your apartment and somebody comes to see it and they're like, what the hell? I'm never going to rent this. But if they put on a coat of paint and do they patch holes and then somebody would rent it. That's what we want. We want somebody to rent it because if they rent it, then you're done. Then you don't have to worry anymore about owing money on the lease.
Mhm. So the next question. So what is the overall process? Do I start the court case once I want to leave, or do I have to talk to my landlord? Do you recommend getting an attorney for this, or can I self-represent myself?
Yeah, so there's no lawsuit to leave, right? Like, so that's the other thing. Like, you could just leave, like, and in fact, I think a lot of people they just go, right? Nobody's thinking like they want to get out of an apartment, they just pack up their stuff and they go, and they don't tell the landlord, they just leave. There's no lawsuit to leave. You don't have to sue your landlord to leave. This, again, there's no our country has a million problems, but like we don't like tether people to the like the land, right? We don't tell them you're not, people can come and go as they want, right? So you don't have to sue your landlord for permission to leave. You can leave when you want. The question is, if you leave, do you owe money, right? That's what this is about. So I always tell people, like, no, you're not going to go. What are you going to sue your landlord about? To sue your landlord to get a judge to declare that you don't owe money like that? Like, why would you waste money doing that? Just wait, right? Like, sometimes too, these things work themselves out. Like, you leave, and let's say your rent again is $2,000, and it takes the landlord 4 months, amazingly, to rent your apartment. Like, is your landlord really going to go after you for $8,000? Like, maybe, right? And landlords are greedy and they often do go after tenants for anything. But like $8,000, sure, they'll go after you in a non-payment case because it means getting the apartment back. But here they have the apartment back. Like, are they going to go do a small claims case against you for 8,000? Like, they might not. So it might just go away. So I would never advise a tenant in this situation to go sue their landlord. I would always say wait to see if your landlord sues you, right? Because they might not. And if they don't, you're good anyway, right? Like this is only about them coming after you for money.
Okay, we have one question left from Wendy. Is there a landlord release letter template to let you out of a?
That's good. Perfect. Yeah. So what I can do, and I'm happy to do this in Jakari, however we can facilitate this, I'll put together like a sample model template letter, and we can get that up either on like the website or we can like have it somehow available at Palante to give out. It's a good idea. We should have that. It's yes, there's a template. It's like the 3 or 4 sentence, but it captures exactly what you want to say. So I think that's important.